bravfathers.com.
Hello, thank you so much for joining me. My name is Joe Paul from bravfathers.com. And today we are going to look into the case of Caroline Flack. And unfortunately, she's passed away. She took her life. And there is a bit of controversy around her story. So, as you may be aware, there is a documentary featuring her mother speaking about how unfair the decision of the police and the crown prosecution was at the time. And uh, as the story goes, it was an unfair decision that led to her taking her life away. And it is very unfortunate uh, that this had to happen. Now, here is, however, another thing to consider, because from the perspective of the events that transpired, it appears that this was a serious case of domestic abuse, or maybe it wasn't. So I'm going to share with you the witness statement from the Crown prosecution about the events that transpired and their explanation as to why they made this choice. So then you can decide for yourself whether or not the Crown prosecution was wrong or whether they are right. Just bear in mind, I'm a layman. Um, yes, I have helped others deal with false allegations of domestic abuse. So I have some experience in family courts, but I'm not a criminal lawyer. I have zero legal qualifications. So these are purely my opinions. It's best you treat them as entertainment. And look it up for yourself. You can go on the Crown Prosecution website, and I'll leave a link in the description so you can look at the witness statement from the prosecutor that was responsible, and you can make up your mind. But first, let's hear some words from Caroline's mother.
And the thing is domestic abuse is so vile and so awful that this really was bad for domestic, because this wasn't domestic violence.
As you heard, Caroline's mother says this was not domestic abuse. So you will make up your own mind after you hear what the Crown prosecution says, because they did think it was domestic abuse, and they stated their reasons for making the decision and why Caroline was charged with a crime. And she was, of course, awaiting her trial when she unfortunately took her life. So we are going to look at the witness statement and from the prosecutor who was in charge, who was responsible, and then you can make up your own mind. So, as I said, I'm not a lawyer. I have no legal qualifications. This is just opinion. Treat it as entertainment. Seek legal advice if this is a matter that relates to you. And of course, I will leave the link in the description, but you can go on the website, on the CPS website, and read the statement for yourself. So let's see what we've got here. So this is where it all started. This is where the whole situation started. So we have officers from the Metropolitan Police Service, MPS, were called to Miss Flack's address in the early hours of 12 December 2019, following a 999 call from her boyfriend, Louis Burton, claiming that he had a cracked head, right? So his head was cracked, and he called 999 because he had a cracked head. That Miss Flack was assaulting him and was breaking stuff. So she was breaking things and she assaulted him. That was the call he made to the police. During the call, Miss Flack self-harmed and Mr. Burden asked for an ambulance, having previously said one was not needed. So if I understand this correctly, there was a lot of blood, and I think that was the photograph that everybody saw. So whilst he was talking to the police, she then cut herself, and that's the blood that we saw in the photograph that made the case known. He was also recorded telling Miss Flack that she was trying to kill him, right? So he was telling her that she's trying to kill him, whatever she was doing. She replied that Mr. Burton was trying to kill her and ruin her life. Police officers who attended the scene had functioning body-worn cameras. So they had their body cams on and they came to see what happened, right? As they do. The footage from those cameras, hereafter referred to as body-worn footage, showed that there had been a disturbance in the property and that both Mr. Flack and Mr. Burton, sorry, Miss Flack and Mr. Burton had blood on them. So they had blood on them, both of them. The latter had a visible injury to his head. So they could see Mr. Burton's injury on his head. Their unsolicited conversations were recorded on the footage. So they were speaking, they were not told to speak or have that conversation, and they were recorded because it was going on. The attending officers also made statements recording their interactions with Mr. Burton and Flack. Right? So self-explanatory. Excuse me. They recorded the interaction. So far, what we are seeing is Mr. Burton called the police. Obviously, the place must have been a mess, and we've seen a photograph. There was blood all over the place. He said she was trying to kill him, and then she also said he was trying to kill her and that he had ruined her life, right? And had some conversations, and the police officers recorded those. Right. So Mr. Burton told officers that he had been asleep when Miss Flack had smashed something over my head. So he was sleeping, he was asleep, and then Miss Caroline Flack, took something and smashed him over the head. So an object. He said he had been hit with a lamp. He later suggested Miss Flack had hit him with a desk fan. So first he said it was a lamp, then later he said it was a desk fan. Mr. Burton also pointed to the cut and said that Miss Flack had sliced him with the glass as well. So that appears that whatever glass she cut herself with, she cut him as well. Later he said, I really need to go. This is mad. She just tried to fucking kill me and my life was nearly over. So obviously he claimed that she was trying to kill him. Miss Flack had injuries to her wrist, right? So probably that's where the blood came from. The assumption is she harmed herself. She accused Mr. Burton of cheating. So when he wanted to leave, whilst the police were there, she said he was cheating, became verbally aggressive towards him, and had to be restrained by officers. So the officers had to hold her back while she was being aggressive to Mr. Burton. Miss Flack admitted that she had struck Mr. Burton, at one point demonstrating how by making a swinging motion with her right arm. So if you read the papers as well, they said she made a motion to demonstrate how she struck him. So far what we are seeing is he was sleeping, she struck him, she admitted herself that she struck him. What she hit him with, we are not clear, but we do know she hit him whilst he was asleep. Right? She hit him whilst he was asleep. Nobody is denying that. She's not denying that. He's making that claim, and the police have recorded that. So Miss Flack was arrested at the property and then taken to the hospital for medical treatment. While she was assessed by the psychiatric team and determined to be a low risk to herself and denied any suicidal and self-harm thoughts. Miss Flack was discharged and taken to Holborn police station where she was held in custody. Sorry, it's a bit cold, you know. During the evening of 12th December 2019, NPS detectives interviewed Ms. Flack under caution. Sorry. And in the presence of her solicitor. So she had a solicitor and she was interviewed in the presence of that solicitor. So she wasn't by herself when she was interviewed. She explained that both she and Mr. Burton were drunk at the time. So she says she was drunk, right? So she was shown, by the way, before she was shown the body-worn footage, Ms. Flack rejected the account given by Mr. Burton of that footage. So whatever Mr. Burton was saying on the footage, which I'm assuming is that she was trying to kill him, she rejected that. Ms. Flack accepted that she had caused the injury to Mr. Burton's head and had seen the bleeding, right? So she had seen the bleeding and she accepted that she injured his head and that he was asleep at the time she struck him. So she accepted that he was sleeping, and then she struck him. So imagine yourself sleeping and somebody strikes you, whether with a hand or with an object, or if you can't imagine yourself, then imagine a friend or a parent or somebody you care about, and you're sleeping or that person is sleeping, and then someone strikes that person in the head. That's what happened. She said that she had hit Mr. Burton with her hand, in which she was holding a mobile telephone, that there had been no intention to hurt him. She had been reckless. So she struck him, but she didn't intend to hurt him with the strike. And she was holding a mobile phone in her hand. Ms. Flack believed that Mr. Burton had made a 999 call to the police to hurt her. So he had done it to hurt her out of spite, presumably. That had caused her to become very upset and self harm. Ms. Flack told the interviewing officers that she had never been diagnosed with mental health problems, right? So she told the interviewing officers she had never been diagnosed, right? So she had no mental problems diagnosed, according to her or according to the interview. Now, on the 13th December 2019, the MPS referred the matter to CPS Direct for a charging decision. This is the first point at which the CPS, so that's the Crown Prosecution, was involved. A senior Crown prosecutor, SCP, in CPS Direct, upon review of the available information, determined that Ms. Flack should be cautioned for the offense. So this is where I believe the mother's case is. So it's acknowledged that it was an offense. Clearly, it was a domestic abuse situation according to law because they were in a relationship. And if you hit somebody in a relationship, that's domestic abuse. Or, of course, there are other forms of abuse like sexual coercive control and so forth. But legally, that's domestic abuse. So, unfortunately for Ms. Flack's mother, based on what we are seeing here, that is classed as domestic abuse. But let's see what happened because she was supposed to be just cautioned for that, right? There wasn't supposed to be any prosecution. And again, that's, as far as I understand, the mother's case. The director's guidance on charging provides that the police, if they disagree with a proposed outcome, can appeal the decision of the CPS and request that the matter be escalated to a legal manager. So again, if the police doesn't agree with a decision, whatever that decision is, they can make an appeal, and then they want a legal manager to review it. So that means somebody who is really well versed with the law to look at the situation. So a different manager looked at that, a higher manager, if I understand correctly, and it was a legal expert, so understands the law. And the MPS appealed the decision to dispose of the case by a way of caution on 13th December 2019. So that's when the Metropolitan Police wanted to appeal that decision. They didn't want a caution. A district crown prosecutor, DCP, in CPS Direct, therefore, undertook a review on the same day, so the same day they checked it, confirmed that all outstanding reasonable lines of inquiry had been pursued, and came to a different view, concluding that a caution was not an appropriate disposal. So the senior manager, or the manager to whom it was escalated, reviewed it and said a caution was not an appropriate disposal. So basically, after review, the Crown prosecution decided that the caution, unfortunately, is not enough to deal with the case, right? So it wasn't the police, because they appealed it, they presented their case, they said, no, you've not looked at the law properly, and this should be looked into further. And that's when the Crown prosecution decided that, sadly, they were going to pursue a charge. So a charge of assault by beating under Section 39 of the Criminal Justice Act 1988 was authorized. The police were also advised that the grounds for seeking a remand in custody were not sustainable. the CPS recommended bail with conditions of non-contact and non-association. So all this basically means is they charged her with assault by beating, right? Because she hit him when he was asleep, among others. And they also said the police couldn't hold her any longer at the time. And what they recommended was that she should be released on bail on condition that she doesn't contact or associate herself with Mr. Burton. So that same day, Ms. Flack was charged by the police and as authorized and bailed to attend Highbury Magistrate Court on 23rd December 2019 for his first hearing. So there were two conditions of bail: that she not contact Mr. Burton directly or indirectly, and that she not go to his home address, right? So she couldn't contact him and she couldn't go to his home address. Otherwise, she'll be back in police custody. She did that. Shortly before the first hearing, it emerged that Ms. Flack had potentially breached her bail condition by seeking to contact Mr. Burton indirectly through Instagram. So she tried to contact him via Instagram, and the police decided they won't take any action on that, but they advised her not to do that again, and she did not do that again. So far we have he was sleeping, she hit him, she cut herself. She was aggressive when the police came. They recorded all that. And then first they're going to be cautioned. The police said, no, let's have a senior person look at it properly from their perspective, from the legal perspective. And upon further legal review, it was determined that this should be charged. So let's look into the detail of why. What are the details? What were the further reasons why Caroline Flack was charged? So we have in paragraph 26. From the point where the matter was first referred to CPS Direct, our task when considering this aspect of the full court test was to assess the primary evidence and material provided by the police. So they looked at the material provided by the police and assessed the primary evidence. So for the reasons explained above and to avoid repetition, I'll not go into the detail of that primary material here. So I'm assuming that was what described earlier. In this case, starting from the discipline review on 13th December 2019 and continuing through to when the matter was transferred, so it was transferred to CPS North London area, the assessment was and remained that there was a realistic prospect of conviction. So they reviewed the case and they decided we could possibly convict this person. So that's so if you have ever been arrested, you already know this. They will look into it and they will decide if they should keep you or whether you should go home with no further action, or whether you're going to be held liable and you're going to have to defend yourself in court. So this is the evidence they used: the content of Mr. Burton's 999 call, the content of body-worn footage, the nature of the injury to Mr. Burton, so I'm assuming that's the cut on the head, Ms. Flack's admission at the scene, and her answers when interviewed. So she admitted that she hit him when he was sleeping, and then she answered the questions when she was interviewed, and that was part of the evidence. The statements of the police who attended at the scene. So the police officers who restrained her when she was being aggressive also made statements. And that was the evidence. Now, here's what's interesting, because the mother's case and a lot of people who defend Caroline say that Mr. Burton was not pursuing charges for what happened to him, right? So here they address this by saying it was recognized from the outset that Mr. Burton was unwilling to cooperate with the prosecution, and so, absent a change of position on his part, would not be likely to make a statement or give evidence at trial, right? So they didn't trust that he would be at a trial because obviously he says he didn't want to press charges. So that's where it came out that he wasn't interested in her being prosecuted. So why did they prosecute her anyway? Nonetheless, there was a realistic prospect of conviction because the case could be presented on admissible evidence gathered by the police and without the need to obtain further evidence from Mr. Burden. This is known as an evidence led prosecution. So, what this means is that they didn't need him, right? They had enough evidence, even without his testimony or without him cooperating with them. They had enough information, they had enough evidence to potentially convict her of the crime of assault by beating, which would fall under domestic abuse because of the nature of the relationship between Ms. Flack and Mr. Burton. So there are some legal details. So there was an overall assessment, and the full court test was and remained satisfied given the matters below. So they will give further reasons. First, the circumstances were serious. They concerned an assault with a weapon on someone who was asleep and therefore defenseless at the time. Self-explanatory. He was sleeping, he couldn't defend himself, and she assaulted him. So to the police and the Crown prosecution, that's very serious. So don't do it. Don't do it. And don't let anybody do it to you. The result was a noticeable injury, which fortunately was not as severe as it might have been. So there was an injury, but it wasn't as bad as it could have been, but it was still bad enough. It was an aggravating feature of the offense that Ms. Flack was intoxicated at the time. So because she was drunk, that makes it worse. Because a lot of people think when you're drunk, it gets you off the hook. It does not. It could actually make it worse. Second, there was no suggestion that Ms. Flack lacked capacity in terms of the offending. There was no issue over her age. That is, she was a mature woman, right? So she was, I believe, 40 at the time. She was a grown-up, she was an adult, and she, was old enough to know not to hit somebody when the person is sleeping. Third, at the time of the charging decision, there was nothing to suggest that Ms. Flack was suffering from a mental illness when the assault occurred. So there was no suggestion that she was mentally ill. In the immediate aftermath of her arrest, Ms. Flack had undergone a psychiatric assessment and had been discharged to the custody of the police. So a psychiatrist looked at her, spoke to her. She had legal representation at her police interview, and as far as the CPS was aware, no issue was raised as to her ability to participate in that interview. So she had a lawyer, and the lawyer did not say there was any issues that would make it harder or impossible or inappropriate for her to be interviewed by the police. So there is some details because there was some other medical records and expertise that was brought forward, right? So you can check it out yourself, but it was not, in any way impacting the decision. So that's why I've skipped those parts. So now we answered the question, why not a caution, right? Why did they escalate it? Why did the Crown prosecution say, no, we actually think on second thought, this has to be upheld. It has to be escalated. So we read, upon appeal, CPS direct reversed the decision to authorize a caution. So they reversed that decision. BCLA subsequently invited consideration of that caution. So that is Ms. Flack's lawyers said to consider that again. A caution was not appropriate in this case, not only because of the seriousness of the offense. So again, defenseless man sleeping and somebody hits him. So not just because of that seriousness, but there are also other reasons, which are offenses of domestic abuse are treated with particular seriousness. So if it's domestic abuse, they will take it very seriously. Guidance makes clear that the evidential stage of the full court test has been satisfied, it will rarely be appropriate to deal with a case by way of a simple caution in cases of domestic violence and abuse. So when it comes to domestic violence and abuse, when they have certain evidence, you cannot get a caution, right? So if, let's say, I'm assuming, because I don't know the law, so don't quote me any way, shape, or form. I'm just my idea that I'm thinking that maybe if you took a chocolate bar from a shop, they might give you a caution, right? Because it's not as serious an offense. I don't know if that's the case. I'm just trying to illustrate. But if it's a domestic abuse situation, so if you harm somebody that you have a familiar relationship with, or even your friend who lives with you, a housemate, if you share a home, that would then be seen as domestic abuse. Now, here's the key part. An admission of guilt to having committed the offense is necessary for a caution. Here, while Miss Flack had admitted to hitting Mr. Burton with a mobile telephone, there had not been and never was a clear and reliable admission of guilt, as she claimed the incident was accidental. So she didn't say, you know what, I did it and I'm sorry. I will not do that again. I apologize or whatever it is, right? She didn't accept that she did it, that she was wrong when she did it. She said it was an accident. So because of that, they can't give her a caution because the caution only applies if you accept that you are guilty, right? If you don't accept that you're guilty, they cannot caution you. So if she felt she was not guilty, but felt they had evidence that says otherwise, then the only alternative then is then to go to court. And of course, that doesn't mean, again, very important, that every time someone does something wrong, they get a chance for a caution, because that's not the case. And furthermore, she sought to justify her actions on the basis Mr. Breton had cheated on her. So she says because he cheated on her, it was okay to do what she did. So for those reasons, they could not give her a caution, right? So to summarize, Mr. Breton was asleep. So imagine you're him, you're sleeping, somebody whacks you in the head with a telephone. You have an injury, there's an argument, you call the police because obviously you'll be scared. You get cut with some glass. The person who hit you also cut herself. And the police arrive. They document the conversation. First, they want to give you a caution. The police did not want to give a caution. It was the Crown prosecution at first said a caution, and then that was appealed because of the seriousness of the offense. Because again, you cannot hit somebody when they are sleeping. And because she couldn't accept she was guilty of hitting him, that she did it intentionally, she couldn't be given a caution. So now you may argue that it was an accident, but she admitted that she hit him. I'm going to be honest and say, as you can tell, that I do think she hit him on purpose. The evidence seems to suggest that way. Obviously, we don't have the chance to see it play out in court, so we don't know. But based on everything that was shown, she hit him. I don't see how somebody hit somebody in the head with a phone by accident and then claims it was okay because it was cheating, because it was because of cheating. That's not right. You cannot do this to people. You cannot hurt people that way. Domestic abuse is a very serious problem. And a lot of people suffer because of domestic abuse. So, why she took her life away, I don't know. I cannot say that the media was fair to her, and I cannot say the media was unfair, because every day we see people dragged to the media, and the same people defending her are not defending those people, right? So I'm not going to mention any names, but there are many people in the media now who have not been charged or have no offenses proven, and yet the public decides they are guilty until they are proven innocent. Every day, the media shows somebody doing something. We see pictures of all kinds of people from all walks of life being dragged to the media for the things they've done. So I do not see the police as treating her differently from the way they treat everybody else. I think it's the opposite. Because she was not given special treatment, it's seen as something wrong was done. Now, I don't like the media. I don't think it's right to, drag people through the mud in your papers. That's very wrong. Excuse me. So I don't agree with that. I don't agree with people bullying Caroline. Um, that was wrong as well, and she shouldn't have experienced that. So that is wrong. What was correct, however, was how the police and the Crown prosecution approached it because of the evidence that they had presented and her own admissions. So let me know what you think. This is my opinion. Again, it's just an opinion of one man. It's very sad either way. It's very sad. Uh, you know, even if she did it, it's still a sad story. We don't need people hurting each other. We need more love. We need more love. So thank you so much for watching. If you have any questions or comments, put them in the comment section. I'll put the link to the paper from the Crown prosecution so you can read it yourself and come to your own conclusion. Maybe you have a different view. I'm very happy to hear your arguments for or counter and any other views you may have. So on this note, I'm going to say goodbye. Thank you for watching, and I'll see you in the next video. This is John Paul from bravefathers.com. Thank you.
bravefathers.com